And
You have
yeah,
Boxing
so
Day. Do you have Boxing Day on the 26th of December?
Canada does.
Yeah, that's
all the satanic holidays are celebrated here. That's why I call it Happy Turkey Day instead of the other term.
Well, you know, speaking of that, when the Constitution was written, it was illegal to celebrate Christmas in America. Because you're right, it is a pagan holiday.
So's Easter.
That's true, yeah. Easter is even worse. That's a celebration of, it's a death.
Esther.
Yeah, exactly.
All right, we ready for the Bivens?
Let's do it.
Okay. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? Just state your name, your position, and the state you're in. This includes notaries. This includes poll workers, anybody that signed an oath to the de facto government. Okay. Second reading. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? If you're a notary, poll worker, even a school board member, anyone that signed an oath to the de facto government, just state your name, state, and your position. Third and final reading. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? Okay. There we go.
Okay, well, so I think I'll just go ahead and share the screen here. I'm going to share the Articles of Confederation. Actually, no, I'll start with the Constitution. So this is the Constitution. And it's interesting to note that the Northwest Ordinance was passed by the Continental Congress 3 months prior to the Constitution. So they had to know that the Constitution was in work. And but so anyways, this is the Constitution. And so let's do a search. Actually, maybe we'll try that. Port. So the first time, oh, look at that. That's Article 6, 7. Article 7, Section 9. Is that right? No, Article 8. That's Article 1, Section 8. Clause 9. to constitute tribunals inferior to the Supreme Court. So they're talking about a Supreme Court, but yet Article 3 sets up the Supreme Court. So in that WFAA TV case, that lawyer argues that because they're talking about this, that's before Article 3, that the Supreme Court they're talking about there is our one Supreme Court, the common law court. Let's see where else it uses the word court. And this is Article 2. Okay, so this is the president's powers. So we support appoint judges to the Supreme Court. Other officers whose appointments not herein otherwise provided for. So, but the important thing to understand here is tribunals inferior to the Supreme Court. So they're talking about legislative courts. This is Congress, right? This is their legislative powers. So they're legislative inferior courts, legislative tribunals. And so it's interesting to note, let's go to the Articles of Confederation. Because the Articles of Confederation don't say anything, or I shouldn't say it doesn't say anything, it doesn't say much about courts. This is the Articles of Confederation right here. And I actually started searching for the word court. Okay, so the article, so this is the very beginning. Notice Article 1, the style of this confederacy shall be the United States of America. So there's at least two. And matter of fact, the United States of America, and nowadays you see like on Air Force One, it has United States of America, there's no the. And the only place I ever seen the United States of America is on Federal Reserve notes and on land patents. That's the only place I've seen it. Anyways, so there's three entities. There's at least three. There's the one found in the Articles of Confederation. There's the one in the Constitution, United States of America. And then there's United States, the United States. Now, the United States is the government itself. Otherwise, the United States of America is the states under the Confederacy, and United States of America is the states under the Union, and it's all of them. It's important to understand what they're talking about. So let's look for the word court in here. So this is Article 3. No, Article 4. And it's interesting, there's a clause similar to this. It says, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, right? And shall be entitled to privileged immunities of free citizens in the several states. There is a very similar clause in the U.S. Constitution to that.
What about the Canadian Bill of Rights?
I don't know. I'd have to look at it. This is I've been dealing with the U.S. one because I've got this lawsuit going on, and I've been articulating this stuff to the federal court. Basically, I filed my petition my demand for relief. And what I told them is that there's actually court cases. I don't remember, what we had talked about previously. Let me pull that lawsuit up and I'll go through some of that. Because the federal courts are not Article 3 courts. Well, they're all legislative, okay? The federal courts are all created by Article 1. And I think I've got that. Right here, 1 Stat 20. This is 1789. I'll share this now. So this is 1 Stat 20. This is the actual statutes at large. This is where it all comes from. And so this is an act to establish the judicial courts of the United States, September 24, 1789. And so they start off by defining what the Supreme Court is there. The Supreme Court of the United States shall consist of a Chief Justice and 5 associate justices. Well, now there's how many? There's 8, because there's a total of 9. And so what happened, I think Roosevelt added some judges onto the Supreme Court to dilute it down because he had a political agenda. And so, that's what happened. But anyway, so it starts off, this is the Supreme Court's a legislative court, which means it's an inferior court. And they talk about the United States is divided into 13 districts, and they define what the districts are. But the important thing is that it's still divided into 13 districts. And so the 13, it's the 13th circuit. There's 13 circuits. The U.S. Court of Appeals has the 13 circuits, and then each circuit has a bunch of districts in it. Like the 5th Circuit is in Louisiana, and the Northern District of Texas is in the 5th Circuit. And Texas actually has 4 districts in it. And so some states have, like Texas has 4 districts. It's probably, I don't know of any states that have more than 4 districts, but there's a lot of states that have, 3, 2, and even 1 district. I think Minnesota only has 1 district. Like New Mexico's just got 1 district. Arizona only has 1 district. Let me think. Yeah, it's just 1 district in Arizona, and that's in the 9th Circuit. Anyways, so the point being is the Supreme Court is a legislative court. It's created by this 1 Stat 73, an act to establish the judicial courts of the United States. And this is a 21-page act of Congress dated 24th of September, 1789. So this is what the issues I was bringing up in my lawsuit. Well, let me see if I can pull up that. Since it's filed, I guess there's no reason why we can't go through it a little bit. I don't want to go through the whole thing because there's a lot of stuff there, and I don't think people are going to want to. It's courts. I have to get some summonses made, and so I'll be doing that Monday. So this is the lawsuit that I got filed. This is the second amended. So what I did is I added a bunch of people. And I changed it to We the People. And, but it's the same case number. I added in a bunch of people, and I'm suing the straw man. Janet Yellen, I heard, resigned. I think it's because I'm suing her butt off. Anyways, yeah, Second Amendment demand for relief to the District of Columbia clerks selling their justice. This action is brought as a collateral attack on a void judgment made by a bought and paid for clerk masquerading as a judge, Patricia Coleman Byers, with their Star Chamber, in conspiracy with bar numbers named herein and their county of Montag Mafia handlers. And there's lots of court cases that talk about this. A void judgment is one which is from its inception was a complete nullity without legal effect. There's Canadian cases that talk about this and British too. So there's lots of cases. A void judgment, insofar as it purports to be a pronouncement of a court, is an absolute nullity. A void order may be attacked directly or collaterally at any time. A void judgment is one from its inception is and forever continues to be absolutely null and without legal efficacy, ineffectual to bind the parties to support a right, of no legal force and effect whatever, incapable of enforcement in any manner to any degree. And comes now to demanding that the District of Columbia clerks in this legislative inferior court selling their justice provide relief. And I used to call it just us, so I've toned it down a little bit. Anyway, selling their justice provide relief against the U.S. citizen wrongdoer mafia named herein by regulating their property. And this is Balzac versus People of Puerto Rico, U.S. Supreme Court. The United States District Court is not a true United States court established under Article 3 to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of making all needful rules and regulations respecting the territory belong to the United States. And this is Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belong to the United States. So, which is the supreme law of the land? Anything in the constitutional laws of any state to the contrary notwithstanding, that's Article 6, Clause 2. And all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, Article 6, Clause 3. And the District of Columbia clerks are required to provide relief for the following reasons, okay? And so I'm going to touch this a little bit, but I'm not going to go into it. We've already talked about this, but under your Code of Law for the District of Columbia, which that's what happened, okay, is they passed a Code of Law for the District of Columbia in 1901, and now that's called the United States Code. Anyways, your Code of Law for the District of Columbia, Title 28 U.S.C., that's United States Code, Section 1331, federal question, because taxation of land originated with an act of Congress under Chapter 45, approved, or is that 55? Let's see. Yeah, no, that's 45. Approved August 5th, 1861 at 12 Stat 292, providing for tax assessors and collectors at Section 9. They're required to execute a bond at Section 10. It's 12 Stat 296. They have an oath of office, Section 11, 12 Stat 297. Secretary of the Treasury to provide regulations, Section 12, 12 Stat 297. A direct tax on lands and lots of ground, Section 13, 12 Stat 297. Board of Assessors at Section 25, 12 Stat 300. Tax liens, Section 33 at 12 Stat 303. And every collector shall exercise or be guilty of any extortion or oppression under color of this act shall be liable, Section 43 at 12 Stat 307, and a penalty for taking a false oath, perjury of oath, Section 47 at 12 Stat 308, and there shall be allowed in full compensation of their services or commission. So they get a piece of the action. So that's why they're busy stealing everything. Anyways, and under your Code of Law for the District of Columbia, 28 U.S.C. 1332, diversity of citizenship, because all wrongdoers are foreign U.S. citizens as required by Texas codes under the Commerce Clause, and the demandant fails to be a U.S. citizen as described herein. And this is a National Mutual Insurance Company versus of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district, that's U.S. citizens, and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. That's another reason why it's Article 4, Section 3, Clause 2. Anyways, so let's one of the things I added in here is this Hale versus Hinkle. They're stealing my land, and this is U.S. Supreme Court 1906, Hale versus Hinkle. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. Okay? There was no warrant, they just stole it. And the individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And so, anyway, so then I go into all the felonies that they're involved in, and that's all this stuff. So let's go to, I'm just trying to think. This District of Columbia Legislative Inferior Court. This inferior legislative court is the District of Columbia Corporation, evidenced by its use of zip code, one of 10 federal subdistricts in the District of Columbia under the Commerce Clause, and this is Code of Law for the District of Columbia, 31 Stat 1190, and said Supreme Court shall divide the district into 10 subdistricts and prescribe the place in each subdistrict where the justice thereof shall have his office for the transaction of business. And your demands for Federal Reserve notes, which are securities, by the way, which are authorized for the District of Columbia only under the Commerce Clause, Article 1, Section 8, Clause 3. And this is the Gold Reserve Act of 1934 at 48 Stat 344. As used in this act, the term United States means government of the United States, and the term currency of the United States means currency which is legal tender in the United States. Well, so then that means legal tender in the government of the United States. And includes United States notes, Treasury notes, gold certificates, silver certificates, Federal Reserve notes, circulating notes of the Federal Reserve banks, all that commercial paper. Okay, that's all just for the District of Columbia only. And it's codified at 12 U.S.C. 411. Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to Federal Reserve banks or the Federal Reserve agents as here and after set forth, and for no other purpose are authorized. Which is the reason why the bar member officers of this District of Columbia Legislative Inferior Court have no trouble assaulting the demandant with their Code of Law rules, denying the demandant due process of law, compelling the disclosure of information as none of their business, converting the demandant's right to justice into a privilege with their filing fee license, and then denying the demandant a remedy for failure to tender their fake money. And this District of Columbia Inferior Legislative Court is busy assaulting the demandant with the zip code so they can justify assaulting the demandant with the Commerce Clause, with the plenary jurisdiction where there are no rights. And this is, again, that same case, Tidewater National Mutual Insurance Company versus Tidewater Transfer Company. And it says right here, in other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia. And through their plenary power, that's dictatorship. Plenary is total. Nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. Which is why the demandant calls it just us. And they're actually bail praise for your Vatican god Satan. And the demandant shakes the dust of the earth, mop his feet against you, Mark 10 and 4, Matthew 10 and 14, Mark 6 and 11, Luke 9 and 5. And we'll all be talking about this before the judgment seat of the true God on Judgment Day. These County of Montag corporate thieves and their bar member handlers and their kangaroo legislative inferior court have no authority over the demandant and fail to provide any evidence of a knowing, willing, intentional contract. And the demandant demands that this District of Columbia clerks and this inferior legislative court provide relief against their U.S. citizen wrongdoers named herein because they are warring against the Constitution. And this is Cooper versus Aaron, U.S. Supreme Court, 1948. No state legislator, executive, or judicial officer can war against the Constitution without violating his undertaking to support it. The legal theory is that we, the people, are the sovereigns. The state and federal officials only are agents. The Constitution of the United States, dated September 17th. This is where I go into talking about the courts. And so, and I can upload this Word file if you want. I think I did last week, didn't I? Does anybody remember?
The amended one, no?
Yeah, right. Yeah. I did. Although I might have made changes to it after I uploaded it. I can upload the one that I have now, which will be the final one. Anyways, the Constitution of the United States, see, when they're talking about the Constitution of the United States, that's talking about the federal government, okay? Dated September 17, 1787, which is still in effect, has never been declared void, and is the oldest written constitution still in effect today. Wherein Article 1, Section 1 states all legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and House of Representatives. And in Section 8, Clause 9, it says Congress shall have power to constitute tribunals inferior to the Supreme Court. The Constitution had not prior to the statement. Oh, that's what I was going to do. Maybe we'll go through the Articles of Confederation first without going too much further, because we were going to go through the where it talks about courts in the Articles of Confederation. So let's do that. Okay, so it does talk about these are talking about legislative courts here. This is the Articles of Confederation. So there it goes back to the beginning. So then let's find the next place. Okay, so this is Article 3. And remember, I was talking about that, where I was talking about the free inhabitants of each state shall be entitled to all privileges. That's also in, I think it's Article 4 of the U.S. Constitution as well. Anyway, but it goes on and it says, full faith and credit shall be given in each of these states to the records, acts, and judicial proceedings of the courts and magistrates of every other state. So it really doesn't, all it does is freedom of speech and debate of Congress shall not be impeached or questioned in any court. And then this is talking about the court of France or Spain. Article 9. And it says appointing courts for the trial of piracies and felonies committed on the high seas, and establishing courts for receiving and determining finality appeals in all cases of captures. Okay, so that's all law of the sea. Provided that no member of Congress shall be appointed a judge of any of the said courts. Says here, so this is basically disputes between the states, okay? So, and all disputes shall be the last resort and appeal all disputes which may arise between two or more states. So, and they're talking about how that court is going to work. Congress shall proceed to nominate out of each state to the Secretary of Congress. See, and that's talking about how that court is going to work. So that's all legislative. Says here, So that looks like it's still talking about the same court, dealing with disputes between the states. So, and then all controversies. Well, that's it. That's all it talks about. See, the Articles of Confederation really don't say anything. They don't really establish any courts. The only court really is Congress when they're administering disputes between the states. But the common law court is operating already, okay? And there's evidence of that all over. And we're going to talk a little bit. So this is in the Articles of Confederation, and we talked about how in the Constitution it says Congress can pass. And so now we're going to go in and into this brief, and we'll talk about this, into this lawsuit. And we'll talk a little bit about it, and we'll see what happens. You know, the proof is going to be in the pudding. Is what the judge says in my lawsuit is really, you know, what's going to happen. Anyways, so now we'll go through this. So there's really nothing or very little in the Articles of Confederation that talk about any court except resolving disputes between the states, and that was it. The Constitution had not, prior to the statement being written, since it was Article 1, provided for a legislative Supreme Court. There were and could not be any doubt, referring to our one Supreme Court in and of common law, which was already established and active in America and the United States of America. It's clear that the Constitution is now setting up another set of courts called legislative courts, and they refer to them to inferior courts, meaning inferior to the already existing common law courts, our one Supreme Court. Article 1 of the Constitution did then and there set up legislative courts inferior to the common law courts, and verified by Article 7 of the amendments of Articles of Amendment to the Constitution, where it grants in suits of common law, no fact tried by a jury shall otherwise be reexamined in any court of the United States than according to the rules of the common law. And this is the Seventh Amendment right here. And the relevant parts right here. The Supreme Court, talked about in Article 3, establishes a legislative inferior Supreme Court of the United States for the District of Columbia, which is established by an act to establish judicial courts of the United States, approved September 24, 1789, and the Code of Law for the District of Columbia at 31 Stat 1189. March 3rd, 1901, establishes the Supreme Court of the District of Columbia, which is also known as the Supreme Court of the United States. And some of the judges, maybe all, are on both. It's, I'm not sure. I mean, I haven't done that research, but so that's what I said. Some of them, maybe all, are on the Supreme Court. The chief judge is on both of them. And the nature of the jurisdiction is determined by the issues being presented. But the only true Article 3 court is our one Supreme Court, a common law court of the people, by the people, and for a people, which was in existence prior to the Constitution. This is that case, Hale versus Henkel, 1906. His rights are such as existed by the law of the land long antecedent to the organization of the state. So law of the land is just another word for common law, okay? And so another phrase for common law. So they're saying right there that there was common law courts long before the organization of the state. This sets the courts of common law separate and apart from legislative courts, such as this court or the 97th District, otherwise being a maritime court, in that any case tried in this court or the 97th District can be reexamined by action of appeal. This makes this court, the 97th District Court, as one of the inferior courts referred to in Article 1, Section 8 of the Constitution of the United States. Note the difference in a trial by jury in common law as to a trial with a jury in legislative inferior courts. The judge in the inferior courts instructs the jury on what they will hear and decide upon and what they will not. There is no such provision in common law with trial with a jury. A common law trial by jury means the jury conducts the trial. So there's no judge there. I mean, sometimes there's all judges are called jurists. I don't know if you know this or not. They're all called jurists. And so they might have a jurist there to advise the jury on different points of law, but that's just someone that's been on a lot of juries. And that's why the judges are all called jurists. And the jury can ignore them. The juries are the one that decide everything. That's why we, the people, make the law. The Northwest Ordinance of 13 July 1787, less than 3 months prior to the Constitution. Is this being recorded, by the way?
Yes, Glenn.
Yes.
Perfect. So the Northwest Ordinance of 13 July 1787, less than 3 months prior to the Constitution, which had never been altered by common consent or in any way or manner, and presently remains in force. The last words of the introduction of the preamble of the Articles of Ordinances state the following articles shall be considered articles of compact. That means a contract between the original states and the people and the states in said territory, and shall forever remain unalterable. So that means that it applies everywhere. Section 14, it is hereby ordained and declared by the authority aforesaid that the following articles shall be considered as articles of compact. Okay, that's a contract between the original states and the people and states in said territory, and shall forever remain unalterable. Was intended to be part of the Articles of Confederation and forever unalterable, and all previous engagements entered into under Article 6, Clause 1, this is Article 6, Clause 1, all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. So, includes the Northwest Ordinance, which is in full force and effect in Texas. So the compact agreement is, the founding fathers were just absolutely brilliant. I'm telling you, they were just brilliant. They just put so much stuff in that Constitution. They just did everything they could. But if we don't assert it, if we don't demand those rights, then, there's not much they can do about that. Anyways, the compact agreement is a federal injunction and is forever unalterable even by legislative Congress or by its legislative Supreme Court or its other inferior courts or the administration. It is protected by Article 6, Section 2, Clause 1 of the Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Remember, I was telling you about that? That's also basically in the Articles of Confederation. Article 2 of the Compact Agreement states the inhabitants of said territory shall always be entitled to writ of habeas corpus and of trial by jury and of judicial proceedings according to the course of the common law. And so always be entitled to habeas corpus, trial by jury, and judicial proceedings according to the course of common law. It's going to be interesting. I'm going to file something about this into a friend of mine that they have in jail in Illinois and see what happens. We're going to try and get him kicked out of there. Anyways, we'll see. That legislative law, statutory law, is in fact an extension of the maritime law, and the 1946 Administrative Procedures Act, Title V, U.S. Code, Section 559, at Section 2, requires the administrative law to be compliance with and in conformity to the Constitution for the United States of America and the common law with all its prohibitions, restrictions, restraints, and limitations imposed by its enumerated Ninth Amendment. Bounds and boundaries. Now, the Ninth Amendment is brilliant because the Ninth Amendment basically brings in everything that's not covered by the other amendments. Okay, so let's look at the Ninth Amendment real quick.
That's the one we hear the most about.
Really? right? This is the Constitution. Okay, so the Ninth Amendment. Yeah, the Ninth Amendment. See, there's court cases that say that U.S. citizens don't have access to the first 8 amendments against the powers of the federal government. It doesn't say anything about the Ninth Amendment. And the Ninth Amendment is the best one of all. Anyways, the Ninth Amendment. Right here. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So you understand that at common law, you have unlimited rights. Okay, you have unlimited rights. The only rights that you don't have are ones that you can't damage someone's person or their property, but that's it. And that's a common law. So you have literally unlimited rights. So the Ninth Amendment is a really powerful one. And then the 10th Amendment, the power is not delegated to the United States by the Constitution or prohibited to it by the states or reserved to the states respectively or to the people. So, but the Ninth Amendment, they're recognizing that there's a whole bunch of amendments, whole bunch of rights that we're not even talking about here. Anyways, so let's go back. So the Maritime Code, otherwise known also as statutory law, being administered in legislative inferior courts. This court and the 97th District Court is evidenced by the maritime gold braid flag or the corporate seal in the courtroom. Also acknowledges that when brought inland beyond the high water mark or the first bridge of any navigable river, they must be brought in compliance with and in conformity to the Constitution for the United States of America and subject to the common law. And this is actually the Judiciary Act, okay, 1 Stat 77. It says right here, and I'm not sure, I wonder what page that's on. Oh, it is on 77. It is, yeah. Okay. Yeah. So, saving to suitors in all cases the right to a common law remedy where the common law is competent to give it, shall also have exclusive original jurisdiction, cognizance of all seizures on land and other waters that is aforesaid made, and all suits for penalties and forfeitures incurred under the laws of the United States. So they're basically saying that, like my case, should have had a common law court, and it would have come out completely different if it did. But they were a busy bunch of thieves. Anyways, and this also at 30 Stat 1161, which is the Judiciary Code that was passed, I think that's in like 1910 or 1920, something like that. Third, and they're basically saying the same things. This was before Title 28, so I'm not sure if it's in Title 28, but that doesn't mean that this stuff doesn't apply. It still definitely applies. Third, of all causes of admiralty and maritime jurisdiction, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. And thus meaning competent common law is not extending in reverse of the high water mark, extending to sea or the jurisdiction of maritime law, or to exercise jurisdiction as stated in the Constitution under Article 1, Section 8, Clause 17. So what that's saying is that all of these legislative courts only have authority in the District of Columbia, wherein it declares the inferior tribunals will exercise exclusive legislative jurisdiction as prescribed by Congress over such district, not exceeding 10 miles square, as may by session of particular states and the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall have for the erection of ports, magazines, arsenals, dockyards, and other needful buildings. And Clause 18, to make all laws which shall be necessary for carrying and proper for carrying into execution the foregoing powers, and for all other powers vested by this Constitution and the government of the United States or in any department or officer thereof. That's all talking about the District of Columbia. Therefore, all legislative courts, this court and the 97th District Court, only have jurisdiction in the District of Columbia under the Commerce Clause, which is why they use zip codes, which are only in the District of Columbia, and commercial paper / Federal Reserve notes / forced loans, which are only for use in the District of Columbia, 12 U.S.C. 411 and the Gold Reserve Act of 1934, 48 Stat 344. Legislative statutory inferior courts themselves admitted the validity of the common law court in Strauss versus Strauss, 1941, which states, that sounds like a divorce case, every system of law known to civilized people generated from or had as its component one of the three well-known systems of ethics, pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. Okay, and so this is a court of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. Whereas we learned that the law of the land means common law, State versus Simmons. See, remember I was telling you that law of the land means common law. See, the Constitution's full of those kinds of words and phrases that are talking about common law. Justice O'Neill speaking for the court, Taylor versus Porter, Webster's definition of the law of the land at Dartmouth, 4 Wheaton, 518 at 581 and 582, which is affirmed by Article 6, Clause 2, which declares that this Constitution shall be the supreme law of the land. That means common law. And the judges in every state shall be bound thereby. In Wiley versus Collins, 1851 acknowledges the common law and the Holy Bible from which it came, which is the foundation of common law as our God-given constitutionally secured right. The 97th Congress declared the Holy Bible to be the Word of God by joint resolution, Public Law 97-280, 96 Stat 1211. A common law Article 3 court of competent jurisdiction, our one Supreme Court, has issued an affidavit of finding of facts, which is attached hereto, and the only superior court of general jurisdiction in this matter, and this inferior legislative court is required to recognize. And that's Ex parte Milligan. Military tribunals cannot try civilians when civil courts are available, which is superior to anything this maritime court can do because this legislative inferior court fails to be an Article 3 court. And this is the United States Balzac versus People of Puerto Rico. A true copy of which is attached here to it, Exhibit 17, all of which is incorporated herein by reference in its entirety. This court is required to provide the demanded a Republican form of government, Article 4, Section 4, as one of we the people. The demandant is a state in this union because we the people are the state and have immunity against these County of Montague corporate thieves under Article 11 and Amendment. The government's but an agency of the state being the sovereign people. A state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. And that's Chisholm versus Georgia. And a Republican form of government fails to include the District of Columbia Commerce Clause under Article 1, Section 8, Clause 3, because of Article 1, Section 8, Clause 17. It says to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. These County of Montague thieves and their bar member handlers engaged in the theft of the demandant's land with their forced rendition. And this is at Hale versus Hinkle. And it talks about among his rights are the right refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. And their inferior legislative maritime court failed to be a trial by jury and absolutely failed to have anything to do with common law as provided in 1 Stat 77, Section 9A, and 36 Stat 1611, Section 256, Part 3. And it's an administrative hearing and failed to have an Article 3 judge, but was an executive branch administrator, which means any decision was a bill of pains and penalties, which is similar to a bill of attainder and prohibited as discussed below. Each of these wrongdoers and their bar member handlers are required by their civil laws to be U.S. citizens. Even if this legislative inferior court could operate as an Article 3 court in this case is not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3, because the wrongdoers are all in the District of Columbia as government employees. In 1861, the southern states walked out of Congress, and Congress ceased to have a quorum, could not conduct business. And on the 15th of April, 1861, 12 Stat 1258, Lincoln ordered Congress to reconvene under executive authority. And 3 months later, on August 5th, 1861, at 12 Stat 292, while operating under executive authority, Congress approved an act to provide increased revenue from imports and to pay interest on the public debt and for other purposes, which precipitated all of this. And Congress has been operating under executive authority ever since. In 1871, under executive authority, Congress created a municipal corporation called United States for the government of the District of Columbia, 16 Stat 419 under Roman law. And now there are two national governments, one which Congress operates outside and independently of the Constitution for U.S. citizens and resident aliens under the Commerce Clause, Article 1, Section 8, Clause 3. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. The legislative inferior Supreme Court ruled on a case that Lincoln failed to like, and Lincoln sent troops to the legislative inferior Supreme Court, which resulted in Rule 45. And that's still there to this day. Just download the rules of the Supreme Court and you'll see it there. All process of this court issues in the name of the President of the United States. Therefore, there is no separation of powers. Everything is under authority of Congress, operating under executive authority, and this legislative inferior court is actually executive branch, operating under Roman law, and all officers of this legislative inferior court are executive branch administrators. And this is, there's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. And the state of Texas is a municipal corporation operating under executive authority that's a subsidiary of the United States Corporation domiciled in the District of Columbia, operating under the Commerce Clause executive authority. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and with the same enactment provide exceptions to its application. Congress passed a code of law for the District of Columbia at 31 Stat 1189, March 3rd, 1901. Which is now known as the United States Code, which the federal courts and state operate under, the Texas Department of Public Safety, the State Commission on Judicial Conduct, the Texas State Bar, and the Texas Bar Foundation, and the Board of Disciplinary Appeals, and the Bowie Independent School District are all subsidiary corporations to the State of Texas Corporation, which is a subsidiary of the 1871 corporation called United States. And all bar members perjure their oath at the drop of a hat by bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. This legislative inferior court is operating under the Demandants Authority because Will Livingston, who ratified this Constitution for the United States of America on behalf of New Jersey, is the demandant's fourth great uncle, which means that the demandant is posterity as found in the preamble, and the demandant's entitled to right of blood. And no civil law can destroy right of blood because all the laws of Congress and Texas are civil laws. And this is the right of blood and kindred cannot be destroyed by any civil law. And this court is operating under power which is derived from the demandant as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. And that's another maxim of law. Therefore, the demandant failed to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant. And John Marshall, the chief judge of the Legislative Inferior Supreme Court of the United States, agreed and said it's impossible for the demandant to confer a sovereignty which will extend over him. And this is McCullough versus Maryland, and that's where I took that from. And the demandant is exempt from these County of Montague thieves, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. Another Supreme Court case, Polyblank Kawakawa versus Polyblank, 1907. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary notwithstanding, Article 6, Clause 2. And we the people fail to be U.S. citizens because a U.S. citizen failed to exist when the Constitution was written. And there's actually two classes of citizens because at the Revolution, the sovereignty devolved onto we the people, which the courts have affirmed, Dred Scott versus Sanford, Yickwo versus Hopkins, and this is Chisholm versus Georgia. At the Revolution, the sovereignty devolved on the people, and they are sovereigns of the country, but they are sovereigns without subjects and have none to govern but themselves. The citizens of America are equal as fellow citizens, joint tenants in the sovereignty. And the legislative inferior courts have ruled that the demandant can be a state citizen without being a U.S. citizen. One may be a citizen of a state, yet not a citizen of the United States. One may be a citizen, and there's actually several cases that talk about that. Both before and after the 14th Amendment, the federal Constitution, it has not been necessary for a person to be a citizen of the U.S. in order to be a citizen of the state. Civil War martial law gave Congress operating under executive authority rise to some emergencies, which resulted in current 13th, 14th, and 15th Amendments. And the 14th Amendment turned things on their head. And this is Colgate versus Harvey. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. So prior to the 14th Amendment, you had to be a state citizen before you could be a U.S. citizen. And after the 14th Amendment, you can just be a U.S. citizen. But the 14th Amendment failed to affect the original state citizens. This is Maxwell versus Dow, that there was a citizenship of the United States and a citizenship of the states, which were distinct from each other depending on different characteristics and circumstances individual. And it was only privileges and immunities of citizens of the United States that were placed by the 14th Amendment under the protection of the federal Constitution, and that the privileges and immunities of citizens of a state, whatever they might be, were not intended to have any additional protection by the paragraph in question, but they must rest for their security and protection where they have heretofore rested, common law. And it continues to this day. Privileges and immunities clause of the 14th Amendment protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. U.S. citizens are created by Congress and therefore corporations under the Commerce Clause. The term resident and citizen of the United States is distinguished from a citizen of one of the several states. Notice citizen of one of the several states is capitalized, in that the former is a special class of citizen created by Congress. And this is Public Law 100-418, August 23rd, 1988. Definitions as used in this section. The term United States business means a United States citizen, which is why the Supreme Court has ruled that for U.S. citizens, the boundaries of the District of Columbia expand throughout the states of the Union. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And in the Kavanaugh hearings, when he was appointed to the legislative inferior Supreme Court, he even said that government can go after a U.S. citizen in Afghanistan. So it's not traced throughout the states of the Union, it's anywhere. Because U.S. citizens are created by Congress, they fail to have any rights not granted by Congress and subject to the plenary power of Congress, which is a dictatorship. Plenary power, complete power over a particular area with no limitations. The term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. And that's Legal Information Institute, which is Cornell Law School. U.S. citizens do not have access to the first 8 amendments to the Constitution against the powers of the federal government. Notice this first 8, that doesn't include the 9th. Anyways, the privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. The right to trial by jury in civil cases guaranteed by the 7th Amendment, and the right to bear arms guaranteed by the Ninth Amendment have been distinctly held not to be privileged immunities as citizens of the United States guaranteed by the 14th Amendment against infringements by the states. And in effect, the same decision was made in respect to the guarantees against prosecution except by indictment of a grand jury contained in the Fifth Amendment. And in respect to the right to be confronted with witnesses contained in the Sixth Amendment. The term citizen of the United States is analogous to the term subject in the common law. The only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States. State citizens are the only ones living under free government, and the County of Montague corporate thieves and their Purdue, Brandon, Fielder, Collins, and Mott LLP bar member handlers, or their bar member bought and paid for clerks selling their Just Us in the inferior legislative 97th District Court, or the District of Columbia clerks masquerading as judges in this legislative inferior court, are incapable of impairing the demandant's right to own land or any of the demandant's rights in this matter. This is Twining versus New Jersey. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. In our country, the people are sovereign, and the government cannot sever its relationship to the people by taking away their citizenship. The demandant demanded to see a bona fide contract with the Catherine Phillips notice of demand, and pursuant to the face of the bill of exchange, silver coin was converted to land, and all the rights and privileges of the original land patent were brought forward, true copies of which are attached here to all of each of which are incorporated herein by reference in their entirety, evidencing no privilege of a discharging debt with limited liability, a contract with commercial paper. The rights of sovereignty extend to all things, persons, and things not privileged within the territory. These wrongdoers each waived their immunity when they perjured their oath of support with the supreme law of the land and demanded commercial paper for their extortion racket. Governments descend to the level of mere private corporation and take on the characteristics of a mere private citizen where private corporate commercial paper and securities is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. And they're personally liable in their private capacity, and they knowingly, willingly, intentionally engage in the felonies described in the Catherine Phillips notice and demand, and other felonies as well. And their bar members, both on the bench and off the bench, are especially liable in this matter. Officers of the court have no immunity when violating a constitutional right, for they are deemed to know the law. These wrongdoers intend to murder the demandant when the demandant arms up and goes out there and defends his right not to be their slave, with lethal force if necessary, and it will be a satanic blood sacrifice to shed innocent blood for their Vatican god Baal when they murder the demandant for defending his right not to be their slave and defending his land, and their thieving bankster buddies get to pillage all the fake money in the Treasury Direct account, 31 CFR 363.6, under the minor estate GlennWinningham Fern in all black capital letters, under the Hague Convention concerning the international administration of the estates of deceased persons, concluded 2nd October 1973, and as the demandant does turn up dead, this is his deathbed testimony. The demandant has never in his life breached the peace, but these screen for low intelligence military police like Thomas named herein breach the peace on a routine basis with their unlawful arrests and their assaults and their thefts, like the theft of the demandant's land they're threatening to do, and their murders, like the murder of the demandant when the demandant exercises his right to resist their slavery and theft with lethal force if necessary, all of which is under the supervision of the bought and paid for mafia clerks like Byers and McGahee, and in conspiracy with the Vatican's Texas State Bar Mafia named herein. So anyways, now let's go to the summary because, whoops. I think yeah. So I'm kind of railing on him here. The state bar. I sued the chief judge of the Supreme Court, Hecht.
regarding another case, or?
Well, no, this is this case. I added in, that's the reason I'm doing a second amended demand for relief. I added in the State Commission on Judicial Conduct. I already had Hecht in there, and I already had the State Bar of Texas, but I'm suing them because they're basically, let's do that. I'm saying that they're, whoops. I'm saying that they have an emerging dictatorship. So Klaus Schwab, Nazi Klaus Schwab and his communist organization, World Economic Forum, has famously said, "You will own nothing, be happy," and these County of Montag mafia thieves and their bar member mafia handlers are giving aid and comfort to the communist enemy in a time of war by engaging in the thefts of the demandant's land in support of Schwab's agenda by exalting the demandant with their District of Columbia Commerce Clause dictatorship, as described herein, which is treason. Let's see where else it is. Whoops. No. Here we go. Nathan Hecht is the chief judge of the Legislative Inferior Supreme Court of Texas that's required to regulate the State Bar of Texas, and the demandants filed bar grievance against more than 90 bar thieves, more than 90 bar thieves called it an inquiry and dismissed under Rule 2.10a. Felonies are okay with these bar members, as well as hindering prosecution felony charges against Heck and every other member of the Legislative Inferior Supreme Court of Texas. And they absolutely refuse to do anything about these bar members or their judicial horrors and their false statements and their barratry, and they're giving aid and comfort to the enemy in a time of war. Obviously, these bar members are doing exactly what Hecht intends and the State Bar of Texas intends. Hecht and his State Bar of Texas buddies and the State Commission on Judicial Conduct buddies are bringing forward an emerging dictatorship for Texas using the Commerce Clause, Article 1, Section 8, Clause 3, by making sure his bar member buddies, both on and off the bench, Paxton, Abbott, and the bar members in the Texas House of Representatives community on the judiciary can make false accusations with impunity so they can call it a contract. Hecht and his bar member buddies are busy populating the prisons by assaulting people with the minor estate so they can collect royalties from the orders of commitment and transcripts. That's found at 31 Stat 1366, where they get the royalties. In addition to their salaries, making it so that most judges retire millionaires with the royalties they pillage from the Texas Treasury Direct minor estate accounts. Texas has a bigger percentage of population in prison than the worst communist dictatorships in history, more than the communist Soviet Union, more than communist China, more than any other state in the Union. And Hecht and his bar member bought and paid for whores selling their justice are busy profiting from it and making it happen because they sit there and play stupid and make rules complicated so their bar member buddies can use the rules as justification to deny justice and sell people into slavery. Some estimates show that 60% of the people in prison are there for victimless crimes. If this was a Christian nation, almost all of these bar members would be put to death. And this Deuteronomy 24:7, if a man be found stealing any of his brethren of the children of Israel and maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. So I kind of rail on them there. And I think that stuff is exactly, it's 100% going on. They're trying to, these bar members it's an emerging dictatorship is what it is. And so hopefully I can nip it in the bud. I guess we'll see. I guarantee you, no matter what happens in this case, there's going to be major change of behavior. Hopefully there's a lot less people going to prison. Anyways, I guess we'll see. Yellen has waived her immunity and is personally liable in her private capacity. That's why she resigned recently, I think, because I sued her. She knows it. All foreign agents of the Vatican failed to register themselves. Wrongdoer corporation. Okay, so that's about it. And then let's go to the summary. That's pretty close. So, whoops. If you want, I can upload. Oh, yeah, I added in a bunch of stuff here about the law. BAR is an acronym which stands for British Accredited Regency. I should have spelt that differently, accredited regency, because all bar members are appointed under authority of the Inns of Court. This is Black's Law Dictionary, 5th edition. Inns of Court, these are certain private unincorporated association in nature of collegiate houses located in London and vested with the exclusive privilege of calling men to the bar, which is one of 4 law schools located in the city of London, which is owned and operated by the Vatican, sent from the concessions to the Pope, 1213. And this is the concessions. We will establish a perpetual obligation and concession to establish that from the proper and special revenues of our said kingdoms for all the service and customs which ye ought to render them, saying in all things the penny of St. Peter, the Roman Church will receive yearly 1,000 marks sterling, namely at the feast of St. Michael, 500 marks, and at Easter, 500 marks. And then it says 700 for the Kingdom of England and 300 for the Kingdom of Ireland. And the concessions to the Pope precipitated the Magna Carta because King John was trying to collect revenue to pay the Vatican. And this is a Canadian court case. The Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessor of John. Neither is it a treaty, for we cannot say it was concluded between 2 legitimate and independent sovereignties, nor between 2 nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between 2 nations in that one of the parties, in virtue of the law of war, can impose its will upon the other. So what they did, think about it, they stuck a sword to his throat and they said, here, king, we want you to sign this. Perlman versus Pichet, Attorney General of Canada, intervenant, reference habeas corpus, 4 Dominion Law Reports, 147. And all bar members are here as regents, British Accredited Regency. A regency is the opposite of jurisdiction of a regent or body of regents. A regent, a person who exercises the ruling power in a kingdom during the minority absence or the disability of the sovereign. That's Black's Law Dictionary, 8th edition, because the District of Columbia, set up in 1871, called United States, went bankrupt in 1933. It's an established fact that the United States federal government's been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and as further evidence that the United States federal government exists today in name only. And that's taken from United States Congressional Record, March 17, 1993. And was owned and operated by the Vatican until Trump seized it back for foreign interference in our election. And this is Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, March 5th, 1903. Says within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. As evidenced by the Roman Achaea military staff carried in battle by all Roman commands and planted on all conquered nations, that is sitting on the right side of the speaker's podium in the United States House of Representatives. Therefore, all bar members are foreign agents of the Roman cult, Vatican, and here to impose the martial law in the District of Columbia only under the Commerce Clause. And this is a U.S. Senate report. Since March 9, 1933, the United States has been in a state of declared national emergency. Under powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's INRI U.S. Senate Report number 93-549, dated November 19, 1973. Do a search for it. You can download the thing. And they fail to register themselves as foreign agents. And anyone who hires an attorney is an imbecile. Clients are also called wards of the court. Second corpus juris secundum, Section 4, attorneys, wards of the court, infants, or persons of unsound mind, which is why the bought and paid for a clerk selling her justice in the 97th District Court Byers was operating her star chamber with her forced bar member because they can presume jurisdiction. In propria persona, in one's own person, it is a rule in pleading that pleas to the jurisdiction to the court must be pled in propria persona, because if pleaded by attorney, they admit the jurisdiction, as an attorney is an officer of the court, and he's presumed to plead after having obtained leaves, which admits the jurisdiction. Black's Law Dictionary, 4th edition. And the defendant's ancestors attempted to prohibit these foreign agents of the Vatican from holding any office of trust requires an oath of office, as found in the original Article 13 of an amendment, taken from a Virginia statutes. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept, retain any present, pension, office, or emolument of any kind from any emperor, king, or foreign power, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. And that's the original Article 13 and amendment taken from Virginia statutes. But it seems to have disappeared around the Civil War time period. So then I go into the Bill of Pains and Penalties, and I've already, well, actually, I didn't talk about this. Texas Penal Code. Texas codes are all bills of pains and penalties. In other words, Texas Penal Code penalties. You see what I'm saying? Because they assault you with their quasi-contract using their District of Columbia Municipal Corporation and Roman law. Assumpsit. In its origin and original an action of tort, assumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract. Based at first only upon an express promise, it was afterwards supported upon an implied promise and even upon a fictitious promise. They lay awake at night dreaming this crap up. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of a distinct form of action, which superseded debt. See, they're using commercial terms here. Became concurrent with account, with case upon a bailment, a warranty, bills of exchange. See, this is all they're using commercial terms. Competed with equity in the case of essentially equitable quasi-contracts, okay? Courts of equity. All these courts are courts of equity. And this is a history of assumpsit, Black's Law Dictionary, 8th edition. Both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. They are contractual in law, but not in fact, being the subject matter of the fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. And that's Salmon and Salmon on Jurisprudence, Sweet and Maxwell, England, which requires the minor estate, U.S. citizen or other fiction. Constructive quasi-contracts are based solely upon the legal fiction or fictional law. So they can assault you with a quasi-contract for their penal action. The words, remember Texas Penal Code, right? The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement, right? Quasi-contract. The words forfeit and penalty are substantially synonymous. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions on the one hand, closely related to criminal prosecutions, and on the other, to actions for private injuries in which the party aggrieved may by statute recover punitive damages. A penal action is one founded entirely upon statute and brought with the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while remedial actions one brought to obtain compensation or indemnity. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. Where an action is founded entirely upon a statute and the only object of it is to recover a penalty or forfeiture, such action is a penal action, which is why they use capitis diminutio. Capitis diminutio is the destruction, a caput of the legal personality. Capitis diminutio, so to speak, whites out the former individual, puts a new one in its place. Between the old and the new individual, legally speaking, nothing in common. A juristic personality may be thus destroyed in one of three ways: by loss of status, libertatis. This is capitis diminutio maxima. By loss of status civitatis, which is capitis diminutio media, and by severance from the agnatic family. This entails capitis diminutio minima. And this is the Institutes, the textbook on the history and system of Roman private law, Black's Law Dictionary, 8th edition. Capitis diminutio maxima, meaning the loss of status, the use of capitalization. The highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away with it all rights of citizenship and family rights. Because capitis diminutio maxima is used when they enslave you, and they are Satanists using fraud and deception to sell you into slavery as collateral for their minor estate. At 31 CFR 363.6, he, the prisoner, has the consequence of his crime not only forfeit his liberty, but all his personal rights, except those which the law and its humanity affords him. He is, for the time being, a slave of the state, which are non-judicial proceedings, because whenever a statute's involved, a fake judge is actually a bought and paid for clerk masquerading as a judge. When acting to enforce a statute and its subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent of the evolved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes as a bought and paid for clerk, as a ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency, which is why it's a bill of pains and penalties and unconstitutional. Also means they have no authority to do anything judicial. Ministerial officers are incompetent to receive grants of power from the legislature, and their attempts to exercise such powers are necessarily nullities. But the reality is they do it all the time, and they did it in this case. And the rest of the stuff I've gone through. So we'll skip that. And if you want, I can upload the Word file. If anybody wants me to do it, I can do it. I uploaded one last week, but I made some changes to it.
Yeah, you've made a lot of changes.
Please. Yes, please.
Okay.
Thank you, Brother Glenn. The only question I have is that, so basically all these extension of district courts within states are literally embassies of the extension of the District of Columbia. Is it not so?
They're all District of Columbia. Okay, and So we, the people, are the state. So automatically we should be saying we have immunity under the 11th Amendment. And and we should be convening our own common law courts, because the common law court trumps it all. And so we should be convening our own common law courts, and we can make all this stuff go away. Summary. So we'll start here, I guess. Yeah. Buyers, the bought and paid for a clerk masquerading as a judge, is required to be under the supervision of an Article 3 judge, and the demandant has serious doubts if there are any Article 3 judge, since they're all foreign agents of the Vatican. And even the legislative inferior Supreme Court of the United States convenes the Vatican's conclave. I don't know if you know that, when they have a meeting. But in any event, the Article 3 Justices Court, on this common law affidavit of finding of facts and judgment, GWF-24-003, and the only superior court of general jurisdiction in this matter. And this legislative inferior court is required to recognize it. Ex parte Milligan, military tribunals cannot try civilians when civil courts are available. Governments are but trustees acting under derived authority and have no power to delegate what's not delegated to them. But the people, as the original fountain, might take away what they have delegated and trust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their pleasure. Nor does the conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both. The sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people to override their will, as declared in the Constitution. John Locke defined tyranny as the exercise of power beyond right. Tyranny is the exercise of power beyond right, which nobody can have a right to, and this is make use of power anyone has in his hands, not for the good of those under it, but for his own private separate advantage. When the governor, however entitled, makes not the law, but his will, the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that, for wherever the power is put in the hands of for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, or subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, 2 Treatises of Government, Book 2, Chapter 18, Section 199 and Section 201. Patrick Henry coined the phrase, "Give me liberty or give me death," after witnessing a man flogged to death for refusing to take a license, which is a contract. And this is Black's Law Dictionary, 1843 edition. License, contracts, a right given by some competent authority. There's 2 kinds of licenses. A license is express or implied, and the filing fee is it's an implied license is one which, though not expressly given, may be presumed from the acts of the party having the right to give it. So when you pay the filing fee, they let you proceed in the case. Okay, so that's a license fee. They're converting a right into a privilege. And this is license tax cases. The requirement of the payment for such licenses is only a mode of imposing taxes on the licensed business, for the prohibition under penalties against carrying on the business without the license is only a mode of enforcing the payment of such taxes. The recognition by the acts of Congress and the power of the right of the states to tax, control, or regulate any business carried on within its limits is entirely consistent with the intention on the part of Congress to tax such business for national purposes. So they can tax businesses. They can't tax people. So they're assaulting you with that minor estate. Think about it. And these District of Columbia bar member force represented the demandant. and made false legal determinations for the demandant, that the demandant was a minor estate, that the demandant is an imbecile, that the demandant's a taxpayer, and the demandant is their slave, so they can tax the demandant. And this is Longborough versus Blake. If it were true that according to the spirit of our Constitution, the power of taxation must be limited by the right of representation, whence is derived the right to lay and collect duties, imposts, and excises within this district. If the principles and liberty in this Constitution forbid the raising of revenue from those who are not representative, do not these principles forbid the raising of it by duties, imposts, excise, and by as well as by direct tax? Okay, so they have to represent you. Think about it. So it's forced representation. And when they make a legal determination for you, they're representing you. And the entire War of Independence consisted of the demandant's ancestors hunting down British tyrants and blowing their brains out because of incidents like what Patrick Henry witnessed. The British tyrants wanted to complete a commercial transaction, which is exactly the same thing these British accredited Regency tyrants in County of Montag are doing in this case. Maybe the demandant will need to take up arms and follow after the traditions of his ancestors. These communists have infiltrated everywhere and have been trying to foment a civil war, and President Trump is giving the opportunity to sign the Insurrection Act, but chose not to in an effort to prevent a civil war by waking the people up to what is going on. These bar members named herein are communists, liars, thieves, and murderers, and intend that the demandant follow after the tradition of his ancestors and arm up and hunt them down and blow their brains out, so they can have an excuse to murder the demandant and shed some innocent blood for the Roman cult god Baal, or in the alternative, if they fail to kill the demandant, sell the demandant into slavery with their quasi-contract in the Texas kangaroo courts under hex supervision, because either way, their thieving bankster buddies get to pillage the fake money in the minor estate treasury direct account. 31 CFR 363.6 under the Hague Convention concerning the international administration of the estates of deceased persons, concluded 2nd of October 1973. And they'll get to collect a commission from the minor estate account with the Treasury, 31 Stat 1366, and if the demandant does turn up dead, this is his deathbed testimony. So anyways, in addition to the minor estate and the Texas tax code being bills of pains and penalties, these County of Montag thieves and their bar member handlers are engaged in all the felonies previously described herein and more. And so this is kind of interesting, because the demandant, this is what I require, okay? Relief required. The demandant requires a declaratory judgment. Actually, a declaratory judgment from the federal courts is about the easiest thing that you can get, okay? The demandant requires a declaratory judgment recognizing this case as res judicata because of common law court, affidavit of fact, and judgment. So I want him to dismiss the case. Think about it. That's what I'm saying. I want you to dismiss this case saying it's res judicata because of this affidavit of fact. And the only Article 3 court in this matter, the only superior court of general jurisdiction in this matter, and further recognizing buyer's void judgment is vacated and the demandant's land returned and their extortion refunded immediately, and these thieves investigated for extortion on other people. The demandant requires a declaratory judgment that the vexatious litigant codes in Texas are unconstitutional, and it's none of the business of Deborah Spisak or Tom Lowe or Stephen Lund or Keith Ogle or the bar members in the Texas House of Representatives, Committee on the Judiciary, or anyone else as to whether the demandant pays any filing fee, tax, extortion. The demandant requires the bond of Deborah Spisak, not a penny more, not a penny less. That's important, okay, because that's coins. The demandant requires the bond of every member of the board of directors for the Montag County Appraisal District and the chief appraiser and the Montag County attorney, not a penny more, not a penny less. The demandant requires a bond of Nathan Hecht as an accomplice to these bar members named herein, not a penny more, not a penny less. I'll bet you he resigns. The demandant requires the bond of Glenn Hegar, he's the Texas comptroller, as an accomplice to these County of Montag thieves, not a penny more, not a penny less. The demandant requires the bonds of the fake judges, Patricia Coleman Byers and Jack McGahee, not a penny more, not a penny less. The demandant requires that Chad Yarbrough be ordered to do his duty to arrest all the County of Montag Mafia wrongdoer thieves named herein and Leah Simonton be ordered, she's the U.S. Attorney, Chad Yarborough's FBI special agent in charge. And Leah Simon be ordered to do her duty to prosecute them for their felonies, especially the bought and paid for clerks selling their Justice, Byers, and McGahey, and the bar member conspirators with the aid of Robin Woods as an accomplice that sold the demandant into slavery, some of which, but not all, is described in the 78 criminal complaints. The demandant requires the bond of Robin Woods, not a penny more, not a penny less. The demandant requires the bonds of each individual member of the State Commission on Judicial Conduct. The demandant requires the bonds of all the members of the Board of Disciplinary Appeals, not a penny more, not a penny less. The demandant requires the bonds of all the bar members in the State Bar of Texas Office of Disciplinary Counsel, not a penny more, not a penny less. The demandant requires the bonds of all bar members named herein, not a penny more, not a penny less, and their bar card revoked, because all bar members are deemed to know the law, therefore it was deliberate, calculated, and malicious. The demandant requires the State Bar of Texas be put into involuntary bankruptcy and dissolved and liquidated, and all their bar members investigated for populating the prisons with their quasi-contracts selling people into slavery. The demandant requires that laymen be appointed to the judiciary and the State Bar of Texas be completely disenfranchised in Texas. The demandant requires all Texas codes about unlicensed practice of law be repealed. The demandant requires $1 billion in lawful money pursuant to the Coinage Act of 1792, and this is where it's talking about that in the common law. The demandant requires the minor estate be dissolved and liquidated yesterday, not today, yesterday. And the demandant does not care what they do with the fake money in the Treasury direct account, wants nothing to do with it. They can put it up their rectal orifice. Anyways, that's the end of it. And then there's my exhibits. And so this is at page 65. So there's about 205 pages of exhibits. Anyways, so
there you go. You toned it down a little bit, I noticed, by not mentioning, that you want to be off by these cabals so that you can be relieved of their ignorance. I'm glad you took that out and laid off that a little bit.
I think that they're sympathetic, and so I figured I got to cut them some slack a little bit, But I think that because quite frankly, I've had a lot of lawsuits, and they usually get dismissed pretty quick, and they haven't said anything except they told me when I have to have service completed. And now that I filed my second amended counterclaim, I expect maybe they'll send me another order saying that when I have to have service done, which will be about 90 days from when I filed it. Anyway, so I've been trying to follow their rules, and so I've been. They went and at the beginning, they sent me this letter saying that I had to do electronic filing. I had 15 days to set up electronic filing, and I responded to their notice. I think I read it in one of our previous calls, and I told them that, sure, no problem, I'll do your electronic filing when you provide your statutory and delegated authority that requires me to get a Social Security number, get a driver's license, get a government-issued ID, get a bank account, so I can do your electronic filing. And I need a Fourth Amendment warrant that requires me to disclose that information. And it was like crickets. Never heard a peep out of them about that afterwards. So anyways.
No, that was back in September.
Yeah. Yeah.
Texas was the worst state. I thought Texas was the most entrepreneurial free. I guess I was wrong.
Well, it's actually, there's a lot of people in prison in Texas. It's very, very tyrannical. But I think that this is going to affect, anytime I've done this kind of stuff, whether I win or lose, it has some really positive effects. And but I think that they're sympathetic towards this. And then plus because they know, and I brought in about the fact that Trump that we're at war and they're giving aid and comfort to the enemy in a time of war. And and I think they know I'm right. And so I think that they're sympathetic. Any judge it's political, no matter what, anyways. But they know that they know what's going on. They know that we're at war, and that there's big stuff happening. I'm telling you, there's you have no idea what I'm hearing about stuff that's going down. It is major stuff. So I'm uploading it right now.
I don't know what is worse, California or Texas.
Sorry?
I said I don't know what is worse, California or Texas.
Well, California is way worse. California is way worse. I think Texas, they both have their problems. There's no doubt. In a way, you can, and really it comes down to the people. And so people are starting to take California back too. But, I think there's Texas definitely is a police state, although that's been changing, because of a lot of it's because of stuff I've been doing, at least around here in the DFW area. The cops, not the last time, but the time before the last time, when they finally got my ID card, they said, "Glenn Fern, you're Glenn Fern." So they've been taking my name in vain, and I kind of like that. So they're basically being told to leave me alone, and that's good. I like that. But I think it's because I'm bringing up the stuff about the fact that Will Livingston's my fourth great uncle. That is like really powerful. They are following the Constitution, and if Will Livingston's my fourth great uncle, then those court cases, then it's treason for them. They can't even think about trying to get me into a contract. That's like big time problem. And now that Trump is won the election, they I'll tell you, there's what I heard today is that Trump's lawyer, who is handling his transition, notified the Biden team, I guess you might say, that they don't want any federal funds to handle the transition. Well, what that's telling me is that Brunson case, I'm hearing that that's already been decided, but the military classified it. And remote viewers have remote viewed Congress adjourning for the last time, and I think that might be getting ready to happen. So what's going to happen, I think, is Congress will adjourn for the last time, and it's going to be really, really chaotic for about the next 6 months. It's going to be really chaotic. There's going to be all sorts of shit happening.
I already knew. Something told me they was not going to let dude in easily. Go for that fight, I'll say. I'm in Florida. Florida, full of crooks and scammers.
Yeah, no doubt. So I think that what's going to happen is it's going to be extremely chaotic for about the next 6 months, and what's going to happen is the markets, they're going to crash the markets. I think that they're saying, I'm hearing that there's going to be a crash.
I already see the charts that the markets are going to crash. Hey, they're going to crash Bitcoin. Well, they're going to heavily deflate the market.
Sorry?
No, I said they're going to heavily deflate the market. I already see the charts, though, but I don't have the confirmation yet.
I think it's going to be, well, I've heard that Bitcoin's going to go down to like 12,000. Silver will go down to like $6. I think that'll just be a really brief spike, but you got to understand that these people that we're dealing with are diabolically evil, and they'd rather burn the house down than turn it over to anybody. And so they will do everything they can to destroy it. But that's all going to work against them, and it's going to work for anybody that's ready. You're going to make a heck of a pile of money. It's going to be huge. And so that's I guess we'll see. I'm hearing it's going to be in April, and they're going to crash the markets. They're talking Bitcoin at 12,000. Think about it. If Bitcoin right now is 100,000, they're saying the Bitcoin is going to peak out in the near term sometime between February 5th and March 5th at 150,000, and then it goes down to 12,000. I mean, that'll be a major drop, and then it'll take off like a bat out of hell after they crash everything, because people will be jumping back in, and it won't be just Bitcoin taking off, because what I'm hearing is they're going to get rid of the IRS, they're going to get rid of the Federal Reserve. Elon Musk is going to shrink the government by about like 80%, and they're going to have tariffs, and so imports are going to be expensive. But then people will start up, be doing it, and we need to build it ourselves. And so there'll be all sorts of work available.
My prediction that Kamala would be hyperinflation and Trump would be deflation.
Well, the dollar will be worthless. Anyways, nobody knows. It's just going to be really chaotic.
Yeah, there's craziness going on here too, Glenn. I just heard today that a big CRA building in Sudbury has completely emptied out. Okay, and with no explanation, nobody in town knows why. All the desks have been cleared out of this huge CRA building. So weird shit's happening. I agree.
Yeah. Wow, that is big. I think it's going to be the same thing in Canada. I think CRA is just an extension of the IRS, and so I've heard that we got 250 or 650 airplane loads of gold from the Vatican when they interfered with our election, and so there's like 3 military bases that are bulging at the seams with gold, and that's what they're going to use to go to lawful money, and so all of that stuff. There's rumors. It's a lot of it's rumors, but it doesn't matter. My attitude is cryptos is because Bitcoin is not a bankster coin. And the bankster coins.
My bad.
Sorry?
No, I was gonna say I'll argue and say if it's anything that should have woke up the people to how the monetary system is, Bitcoin should have been the one that wait a minute. So this is how our money system is running. Monetary system is running.
Yeah. So, anyways, I guess I'm about done. Does anybody have any questions or anything? I think that once we understand, we the people have to start convening our common law courts. We the people have the power. We always have had the power, and we have a bunch of pirates that are running roughshod over us because we the people. Isaiah said it. My people perish for lack of knowledge. So we the people need to start convening our common law courts and start holding our own trials. And this is that WFAA case has some great material in it that you can use to enforce your judgments.
I'm really happy you put that in there. That's very impactful.
Absolutely. The founding fathers were brilliant, and Lori, you need to get away from that communist Canada because I'm not sure what you can do up there, but down here at least you got the protection of the Constitution.
I was looking at a motorhome today, so it's getting close. I'm getting there.
All right.
I was earning money this week to get there, so I'm stepping in the right direction. But no, I want to leave you with a compliment if nobody has any further questions.
Well, I would just like to correct Glenn on the CRA is not under the IRS or anything. CRA is under the tax collectors for the IMF as the IRS is. So we're both crown colonies, and the CRA and IRS are kind of separate in that sense. That's all.
I'll let you have that one. You're right there. I agree. They're both International Monetary Fund. Anyways,
I got a quick.
What's that?
You're talking about cryptocurrency. Are any of those wallets safe that you can sign up for without having any ID, or you need a valid ID?
Well, you can get you can get wallets on your phone. I use the Exodus wallet, but there's also a Coinomi wallet. There's a Jax wallet. I wouldn't get any wallets that where the currency is kept on an exchange. I have a Coinbase account, and I had to do the KYC for that. But what happened is I had that account long before they ever needed the KYC. So then when they tried to make me do the KYC, I filed felony criminal complaints against all the board of directors and sent them to the FBI and all of that stuff. And so that I think that kind of inoculates myself against. So anyways, but you don't want to have, you want to have, like when you get the Jax wallet, there's a seed phrase, or the Coinomi wallet on your phone. Get that seed phrase and write it down and put it somewhere safe, because like with my phone, I can dump my phone in a bucket of water and everything will be fried. And all I have to do is get another phone, download the app, put that seed phrase in the app, and everything is still there, because the cryptos are really kept in the blockchain. They're not kept in my wallet. And but it's not on an exchange anywhere. Exchanges are risky. Exchanges are like banks. So I don't keep anything more on an exchange than what I have to have there for some purpose. And other than that, I keep it private in a wallet, and I have more than one wallet, because that way, if you got to treat it like it's an investment, and if you lose one, well, you got other ones. You know what I mean? Don't keep it all in one wallet. And somebody hacks it or something, I don't know how they can hack it. If you're real careful with it, then I can't see how anybody can hack it. But, there's a friend of mine that somebody stole 10 Bitcoins. And that's, look at the price of Bitcoin right now. That's $1 million, or just about $1 million. And somebody stole 10 Bitcoins from him. And he's got the FBI investigating it. But that's a hell of a pile of money.
How'd he get it? How'd they get it how'd they hack his account?
It was a girlfriend, I guess. That's the thing, is that guys are kind of
spies. Oh, you don't need to say anymore. We got it. We've all been there. Some different sex.
Yeah, some people you can trust and some people you can't, but I wouldn't trust, a girlfriend unless I knew her for a long time, and I'd test her, you know what I mean? And get to know if some people are just not trustworthy, and you just don't know. And, so at any rate, you have to be careful. That's for sure. But there's wallets that you can have, and the wallet's on your phone, and Exodus is one, Coinomi is another one, Jax is another one, and it's not kept in some exchange.
Yeah, I use PulseX myself, which is
what?
PulseX, PulseX Trade. They're quite.
Never heard of it.
They're quite knowledgeable.
I would be careful. It's not one I've heard of, and so I'm suspicious of it right off the bat.
Well, you know where I'm stationed, so I'm working within the parameters, right?
Yeah, I understand. You're kind of stuck.
So if there's nobody else has any questions, that compliment that I wanted to lay on you is that there's been folks in our chat that have been up against these magistrates in your great state of Texas, and you know what they say about the Republic of Texas? They say that that's been demolished long ago. Well, the greatest compliment is denial, correct? So
I still know. I'm a senator with the Republic of Texas, and so the Republic of Texas is alive and well, and we hold Congress once a month, and we actually, the House of Representatives meets a lot more often. I'm in the Senate, so that's why I like the Senate, because I don't have a lot of meetings. But the House of Representatives has a lot of meetings. They get wore down big time. But so yeah, we have it's lawful government. The Republic of Texas, I think, is the only lawful government left on the planet. And so, anyways, yep, Republic of Texas is alive and well.
yeah, we got to get some T-shirts made up of that, so it gets out there.
We got T-shirts. If you come down here, I'll make sure you get one.
Sounds awesome. So thank you for coming on tonight, even though it's your holiday week around there, your holiday weekend. I appreciate you giving us that time tonight and sharing us, your amended forfeiture case that many of us need to learn from. So I wish you well, and I hope that you get some answers regarding all that. And I'm really curious to see how you're going to be delivering all of these affidavits to everybody. That's going to be an expensive process. How's that going to come down?
Well, a bunch of them I already served. So I won't, what I'll do is I'll just mail them a copy, and now it's their lawyers I'm dealing with. And so there's a bunch of them I've already served, and there's like 2 or 3 lawyers that I have to send it to. So that's going to save me quite a bit there. And some of them I actually have to do the initial service on. So I'll have to hire process servers. I have a friend of mine that he'll do a bunch of them. And it's kind of like keeping it in the family that way. But some of them I might have to hire like county sheriffs or U.S. Marshals or somebody to do it, because some of them are like judges are hard to serve. They don't make it easy.
Well, they're hard to pinpoint. They don't want to be. Can't you send it or initiate it through their court of clerk, like direct it to the court of clerk and double envelope it, so when the court of clerk opens it up, she's got a private letter that she needs to direct to the head judge. Is that an option to get them?
Yeah, the judge, you can actually serve him at his court. Okay, you don't have to necessarily serve it to him physically. I'm not positive about that. Some of the rules and stuff, they're nitpicky, and their lawyers like to get them off the hook if they can. And so that's why I was thinking about getting the U.S. Marshals or somebody like that to do it, because they'll do it right. And, it'll cost me like, maybe $150 or something like that. But there's not too many that I have to serve that way.
But you're not dealing with a postage strike like I am here.
Sorry?
I'm glad you're not having to deal with the postage labor strike like I am here. So, I don't know.
What's all that noise?
I have no idea who that was. There we go. No, the postal strike up here has been going on almost a month now, so it's like everything is sitting, so nothing is getting done, right?
Right. You have to use couriers.
Yeah, they're doing really good right now.
I'll bet they are. Anyways, okay. Well, nice talking to you guys. It's a networking thing.
Thank you, Glenn.
It is all.
Thank you.
It is. I will forward you the recording once it comes into my saved messages. And yeah, thank you so much. I really appreciate it.
All right. Well, I'm spreading the word. We need to get our common law courts going. We have no idea the power that they have. All right. Take care.
You too, Glenn. Ciao.
See ya.
Take care.
Hey Lee, check your DM.
Hey, it looks like the recording is still going, just for your information.